please come to order? A quorum is present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 5B and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. The committee will continue to use the electronic system for recorded votes on amendments and passage of the bills before the committee. Of course, should any technical issues arise, which I do not anticipate, we will immediately transition to traditional roll call votes. Any procedural or motion-related votes during today's markup will be dispensed with by a traditional roll call vote. Now, pursuant to notice, I call up a report containing a resolution recommending that the House of Representatives find former President William J. Clinton in contempt of Congress for refusal to comply with a duly issued subpoena issued by this committee. The clerk will report the report, which has been distributed in advance.
A report containing a House resolution recommending that the House of Representatives find former President William J. Clinton in contempt of Congress for refusal to comply with a duly issued subpoena issued by the Committee on Oversight and Government Reform.
I ask unanimous consent that the report be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will please report the amendment.
An amendment in the nature of a substitute to the contempt report is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I now recognize myself for 5 minutes for a statement on the report. Today, the House Committee on Oversight and Government Reform meets to advance 2 resolutions recommending that the House of Representatives find former President Bill Clinton and former Secretary of State Hillary Clinton in contempt of Congress for refusing to comply with duly issued subpoenas. The committee does not take this action lightly, but subpoenas are not mere suggestions. They carry the force of law and require compliance. Former President Clinton and Secretary Clinton were legally required to appear for depositions before this committee. They refused. As Democrat Ranking Member Garcia stated, and I quote, "Defying a congressional subpoena is highly illegal," end quote. He also stated, and I quote, "No one is above the law." Actions have consequences. 6 months ago, Republicans and Democrats on the House Oversight Committee's Federal Law Enforcement Subcommittee unanimously approved deposition subpoenas for the Clintons by voice vote as part of our investigation into the federal government's handling of the Jeffrey Epstein and Ghislaine Maxwell criminal cases. More than 5 months ago, I issued those bipartisan subpoenas. The Clintons' testimony is critical to understanding Epstein's sex trafficking network and the ways he sought to curry favor and influence to shield himself from scrutiny. Their testimony may also inform how Congress can strengthen laws to better combat human trafficking. Since issuing the subpoenas, this committee has acted in good faith. We've offered flexibility on scheduling. The response we received was not cooperation, but defiance, marked by repeated delays, excuses, and obstruction. The Clintons claim they have been treated unfairly because this committee accepted written statements under penalty of perjury from former U.S. Attorneys General Holder, Lynch, Sessions, and Garland, as well as former FBI Director Comey. Those written statements were accepted because none of those officials recalled information relevant to the Epstein investigation, nor did they have personal relationships with Epstein. By contrast, the committee required in-person testimony from former U.S. Attorney General Barr and former U.S. Secretary of Labor and U.S. Attorney Acosta, both Republicans, because they possessed information directly relevant to the investigation. The Clintons are in a fundamentally different category. They had documented relationships with Epstein and Maxwell, evidenced by numerous photographs, flight log records, wedding invitations, and other materials. Some of these photos can be seen here. We repeatedly informed the Clintons' attorney that written statements would not be accepted. The subpoenas required depositions. Federal courts have consistently held that witnesses may not impose their own conditions upon the manner of congressional inquiry. Yet the Clintons attempted to do exactly that, submitting brief, bulleted written statements that are neither comprehensive nor responsive to the committee's many unanswered questions. No witness, not a former president or a private citizen, may willfully defy a duly issued congressional subpoena without consequence. But that is what the Clintons did, and that is why we are here today. I would expect bipartisan support for enforcing those subpoenas by voting in favor of these resolutions. Unfortunately, it appears that Ranking Member Garcia has chosen to follow marching orders designed to distract from the issue at hand. I hope I'm wrong about this. Over the weekend, Ranking Member Garcia made clear that Democrats intend to divert attention from the Clintons by instead calling for Attorney General Bondi to be held in contempt. The difference is clear. Attorney General Bondi and the Department of Justice are producing documents. While the pace is slower than any of us would prefer and must speed up, I believe that much of the delay involves the Department of Justice trying to take care to redact victims' personal information. By contrast, the Clintons have flatly refused to appear at all, despite repeated warnings that the committee would move forward with contempt proceedings. Today, the Clintons must be held accountable for their actions, and Democrats must support these measures or they will be exposed as hypocrites. We must do what is necessary to uphold Congress's investigative authority, which is imperative to the legislative process. And we are doing so to demonstrate to the American people that justice is applied equally to everyone, regardless of position, pedigree, or prestige. I urge my colleagues to support this contempt report. I now yield to Ranking Member Garcia for his opening statement.
Thank you, Mr. Chairman. I want to just make one thing clear. Oversight Democrats, from the start of this investigation, have been crystal clear that we're willing to talk to anyone who has information about Jeffrey Epstein and his crimes. And we don't care if they're wealthy, their position, if they're Democrats or Republicans. And we agree, subpoenas issued by our committee must always be respected. No president or former president is above the law. And I think every single person on this committee agrees with that. In fact, I appreciate that you brought those posters. Mr. Comer, can I actually see that? Would you mind if I actually use that poster that you brought? The ones that you put up? The two that you put up earlier? I'll put those up in a sec. Now, this committee, from day one, and we agree, we've had questions for former President Clinton. And as you know, former President Clinton has begun answering some of those questions in a signed declaration that this committee has received recently, including last week. We know that President Clinton has offered to answer additional questions in different formats. He's also called for a full release of the files immediately, which you or no one in this committee has actually done. It's interesting that it's this subpoena only that Republicans and the chairman have been obsessed about putting all their energy behind. Now, we also want President Clinton to answer questions. In fact, he should continue to answer the questions from this committee, as he has begun doing in not just a signed declaration, but also in other offers to meet with this committee, of which you have rejected. But it's also incredibly interesting that this energy you have to attack whoever you believe your political opponents are, you are unwilling to use on Ghislaine Maxwell, a monster who has trafficked, abused, and raped children and women, and which every committee member in this body knows should be in front of this committee. Where is the contempt charges to bring her into this committee to answer the questions? And I hope that you would agree, Mr. Comer, that that should be one of our top priorities. And let's talk about the president. Your former colleague, Marjorie Taylor Greene, on this committee reported that Trump told her that he wanted to continue his cover-up because, quote, my friends will get hurt. Donald Trump is leading a White House cover-up right now of the Epstein files. And we all know that Epstein himself said that Donald Trump was his best friend for over 10 years. And it is shameful, illegal, and unconstitutional that the Department of Justice has released one 1% of the files. 1% of the files. Where is the pressure to get Pam Bondi to release the files? Instead, you're focused, and the committee's focused, on whoever you perceive to be your enemies, and the enemies of Donald Trump. Because let's be clear, we want to talk to President Bill Clinton. We want him to answer our questions. We also want Ghislaine Maxwell to answer our questions. We also want to understand why Pam Bondi refuses to release all the files. 1% of the files have released. Millions have been left. No publications for weeks. That is a crime. And so this White House cover-up continues every single day that the files are not released. And yet, where are those calls, Mr. Comer? You're saying they're complying. That is both a lie and shameful. It's time to end this White House cover-up. I want to yield to Ranking Member of the Subcommittee on Federal Law Enforcement, Summer Lee, who originally made the motion to subpoena Attorney General Pam Bondi.
Thank you, Mr. Ranking Member. I just want us to speak plainly and lay the facts out what's really happened in this committee. We are 1 week out from Bill and Hillary Clinton, who did not show up for their depositions. 1 week, and we're already having a markup to hold them in contempt. Meanwhile, the Department of Justice has been legally obligated to hand over the full unredacted Epstein files to this committee since August, the same exact subpoena that they are using to hold the Clintons in contempt. And please note that these resolutions are allowing the DOJ to prosecute the Clintons for the exact same things that the DOJ itself is violating. They have handed over 1% of the files and heavily redacted. We are 5 months overdue, Mr. Comer, if you've made no effort to bring in Pam Bondi. So no, the difference is not clear. You have made no effort to demand any answers, to exert any pressure. So with that, Mr. Chair, I do have an amendment at the desk which would hold Pam Bondi in contempt for noncompliance with the bipartisan subpoena that you issued on August 5th, 2025. I hope that my colleagues will support. I yield back.
I agree. We need to hear from Ghislaine Maxwell. We've been trying to get her in for a deposition, and her lawyers have been saying that she's going to plead the 5th, but we have nailed down a date, February 9th, where Ghislaine Maxwell will be deposed by this committee. Now, her lawyers have made it clear that she's going to plead the 5th. I hope she changes her mind, because I want to hear from her, just like I want to hear from
her.
What's that?
You said the difference is clear.
Turn on your mic, Trump.
It is.
What would you say?
If the difference is clear, the difference here is that they are also trying to negotiate. She says she doesn't want to do it. You have not moved in the same way. So you are actually not applying the same standard here across the board. The DOJ is in the same exact subpoena. Ghislaine Maxwell says she won't do it. Bring her in then.
You're out of order, Ms. Lee. You're out of order. So we were going to depose Ghislaine Maxwell February 9th.
Where are the contempt charges, Mr. Chairman?
You're out of order too, Mr. Garcia. And we will proceed with that deposition. Ms. Lee said the Clintons just missed their deadline by a week. We have been negotiating with the Clinton attorneys for 5 months.
Mr. Chairman,
5 months.
Whose time are we speaking on right now?
This is my time. This is my time. I recognize myself, so I have 5 minutes.
You already had your 5 minutes.
All right, well, I'm about finished anyway. I haven't used 5 minutes. I've used about 1 minute. But
you used your full 5 minutes, sir.
no, I haven't used the 5 minutes, Mr. Garcia. So if does any other member seek recognition on the underlying bill? Ms. Luna.
So I think this is really important for everyone to get context, and also I just actually talked to Todd Blanche this morning. And as we proceed in this committee today, I wanted to give an update, but also to let you all know that Todd Blanche has told me that he's willing to talk to any of you. And I think it would be very important as we proceed with the seriousness of this investigation, specifically pertaining to Jeffrey Epstein, that there's open dialogue directly with the DOJ. When I went to move to hold Garland in contempt of Congress, part of the issue was he wasn't even willing to talk to Congress, period, at least not some of the members that were concerned about some of those audio tapes. But specifically pertaining to the Jeffrey Epstein update, as of right now, what I've been told by Mr. Blanche is that the files, and I think in total it was over 5 million files, actually have finished review at the DOJ. They've had 500 attorneys from NSD, the Southern District of Florida, SDNY, and the FBI basically working on this 6 days a week to get these files appropriately redacted with victim information. But specifically what the hang-up is for the file release is the judge in New York that issued, that made the order from the SDNY's prosecutor's office, Jay Clayton, basically certified under oath that there would be a review to protect some of the victim information. And so that's part of the reason why it has, I guess, been more of a delay. I do think that this information needs to be released, but it's important to provide context that unless we're going to bring in the judge in New York, which I agree with him, I do think that there needs to be a proper review of the documents if it's pertaining to victim information. It's just important to know that context. But I would be happy to Garcia, I'd be happy to facilitate that phone call, give you his personal cell phone. He said he would actually like to talk to all of you guys. And I would encourage you guys to actually engage in that conversation because I do think this is important. And then also, too, a last update. I was told, and I've been trying to obtain information of one victim specifically. If you have victims that specifically want their files, they will actually take those names and get whatever files they can to them. So some of the Democrats are working with some of the victims. I'm working with some of them, but it's important to know for context. So I yield my time.
Very, very good. And would you yield a couple of, you've got 2 minutes left, but I just want to make clear, like most everyone on this committee, I do a lot of interviews, and I have stated repeatedly, publicly, on conservative networks, liberal networks, and everything in between, that we want the Epstein documents released. And I appreciate the update from Ms. Luna on the progress. They have been complying. We all wish that it was moving much faster, but there are a lot of documents. And if you'll remember the last document dump that the Department of Justice released, there were many people on this committee, on the Democrat side, that were very critical, saying there weren't enough redactions. So they are making triple and quadruple sure that the victim's personal information is redacted. Now, do any other members wish to be heard? Chair recognizes Mr. Mfume.
Mr. Chairman, I yield to the ranking member Garcia.
Thank you, sir. Representative Luna, I appreciate the statements, but I just want to be clear that is a lie, and here is why. Mr. Blanche said that they've been reviewing the documents since the passage of the law, the Contempt law. We have had a legal subpoena in place since the summer, since July. It's been the job of the DOJ to comply with this law since a subpoena passed the subcommittee of this body. Since that subpoena passed in July, we've received 33,000 documents, of which 99% of them were already public documents. And so when we talk about complying with the law, you have to talk about complying with the very subpoena that this committee actually passed in a bipartisan way. And so Mr. Blanche is talking about the Epstein Files law, which we should have received all the documents already per the actual law that was voted on. There has been little to zero production of this committee's requests. And so Mr. Blanche is wrong, and he's not being truthful to this committee and to you. Thank you.
Mr. Chairman, I yield remaining time to Ms. Summer, who has the underlying motion, and I know that you said that we would be dealing with that. I just don't think she had enough time to explain her position on it.
Ms. Lee?
Thank you, Mr. Mfume. I actually do appreciate that. And I would like to really emphasize that 1% of the files is insulting. It's insulting. In fact, when we consider that Pam Bondi herself has publicly stated that the files exist. She publicly stated that she had already given Donald Trump that information. So it is a little bit concerning that you have not moved in the way that you said you would. This type of energy could be well spent on the DOJ. It could be well spent on not just saying that you want us to release the files. You have power here. This markup is evidence that you were never serious about an honest bipartisan investigation, that you always intended to use this as a one-sided political hit job. Because if you had your way, we actually would have recessed this summer before we were able to force that bipartisan subpoena through the Subcommittee on Federal Law Enforcement. So when we think about this kangaroo court into this honesty that's happening right here, right? It dishonors the integrity of our committee. and the survivors who have put themselves at risk for justice. We all remember the roundtable where many of us sat and listened to the survivors. We listened to their stories, and one of them spoke and said that she doesn't know if we're good liars or if we're telling the truth. But for the first time, she is hoping that something actually happens here. We left that roundtable, and Mr. Coomer, you yourself said that you wanted to honor those victims, to let Pam Bondi off the hook, to let others who are obviously in those fouls off the hook, is unacceptable. We cannot investigate this fully if we do not have the full files. We cannot see all there is to see if the DOJ is not complying. We cannot move forward. Being in the minority party gives us limited options for actions, and we all must be unwilling to wait if you are not going to subpoena the files. So I thank you, Mr. Mfume, and I yield back.
Thank you, Mr. Chairman. I yield back also.
Do any other members? Mr. Gosar, when this started, everyone was demanding that we subpoena the Epstein estate. That wasn't in the discharge petition, but I issued a subpoena to the estate. When we met with the victims, when we met privately for 2 hours, Ms. Lee was there and Ms. Crockett and, more than half the committee. They were demanding that we subpoena the estate, and we did. We got every document from the estate. There were people that said, oh, there are going to be a lot of questions answered. There'll be names and all. We've subpoenaed every document, every picture, everything from the estate. We never held back. We've been serious. We've all supported the full release of the documents. As I've stated many times publicly, we wish the process was going quicker. That's a lot of documents, a lot of redactions, a lot of eyes have to be put on this. So the Department of Justice is complying. Now, with respect to Maxwell and the Clintons are not treated differently. Maxwell was always, she was willing to appear, but made very clear she would take the Fifth Amendment. The Clintons refused to appear. The Clintons refused to appear. And one of the proposals that Clinton made was if we would let Hillary Clinton off, then Mr. Garcia and I could travel to Mr. Clinton's house and bring one staffer and take notes, but no transcript. That's not even a thing, and you all know that. The media, I'm sure, would require a transcript. There's no real investigation without a transcript. So, what few counter proposals the Clintons' massive legal team has made aren't acceptable, and I don't think anyone is going to stand up here and willing to publicly argue that they were. So does any other member seek recognition? Mr. Frost.
Thank you, Mr. Chairman. The American people deserve full transparency, and anyone who has relevant information about Jeffrey Epstein's crimes must be compelled to come forward and share with this committee. Wealth and power cannot shield people from accountability from this committee. It is the victims of these horrific crimes who deserve protection, not Jeffrey Epstein and the people associated with him. We all agree we want to hear from former President Bill Clinton. But committee Republicans have failed to conduct a serious investigation. For instance, they refused to hold Attorney General Pam Bondi in contempt for her failure to release 99% of the Epstein files on a bipartisan law that we all passed on the House floor, and B, that had a deadline. And B, they refused to hold Ghislaine Maxwell accountable for defying this committee's subpoenas. We all know that President Trump has a long-standing relationship with Jeffrey Epstein. His administration continues to obstruct the release of the Epstein files for this reason. We've seen photos of them together. Even Elon Musk posted, @Real Donald Trump is in the Epstein files. That's the real reason why they have not been made public. President Trump's own Mar-a-Lago club appears to come up often in connection to Jeffrey Epstein. From reporting, we know that Epstein was deeply involved with Mar-a-Lago. He was a frequent visitor to the club for years. The club sent employees, usually young women, to Epstein's mansion for massages, manicures, and other spa services. Staff members from the club made frequent calls to Epstein's home in Palm Beach, and on these calls, Epstein engaged in sexually suggestive behavior, such as exposing himself And in 2000, Ghislaine Maxwell recruited Epstein's trafficking victim from Mar-a-Lago, where she was working as an employee. This committee must also investigate what Mar-a-Lago Club members and the staff knew about Jeffrey Epstein's crimes. Getting documents from Mar-a-Lago is about uncovering evidence, holding these people accountable, and doing right by the victims of these horrific crimes. So we are all for making sure that we hear from everyone. I don't care if you're a Democrat, I don't care if you're a Republican. I'm tired of rich people trying to evade justice and accountability, period. But you can't do it just for the party you disagree with. You can't do it in a politically motivated way. So here's the opportunity to show it's not a politically motivated thing. Let's also make sure that we get these documents from Mar-a-Lago. So with that, pursuant to Clause 2K6 of House Rule 11, I move that the House shall subpoena the Mar-a-Lago Club and all entities under common ownership or control with the Mar-a-Lago Club to provide the House Committee on Oversight and Government Reform with 1. All documents, communications, and materials related to Jeffrey Epstein, to include but not limited to personnel files and records, client files and records, massage and spa services records, complaints and grievances filed against Jeffrey Epstein, internal communications, and billing statements. 2. A list of all Mar-a-Lago Club personnel who provided massages on behalf of the Mar-a-Lago Club between 1997 and 2003, regardless of whether such personnel were contractors or formerly employed masseuses or otherwise. And 3, a list of all Mar-a-Lago Club personnel who were employed as or acted as managers of the Mar-a-Lago Club Spa between 1997 and 2003.
A motion was made by Mr. Frost. The motion is improper as the item is not on the agenda. Any other? Chair recognizes.
So Mr. Chair, you want to use procedure to push back accountability?
No, we're holding people accountable today. That's why we're here.
Well, why won't you move to make sure that we get the relevant documents from Mar-a-Lago, that I just read this? And you're saying it's because it's not on the agenda that we can't move forward with this? You have full discretion of this committee to say, you know what, let's have a vote in a bipartisan way to say we want the documents from Mar-a-Lago.
I don't have full discretion. It's in the rules. We vote on a rules package at the beginning of the
You're able
Congress.
to say right now that we can vote on this.
We cannot vote on it. It's in our rules. We'll be breaking our rules. We have to apply to the rules, too. We're not like the Clintons.
No. You are hiding behind process to protect these Mar-a-Lago documents, and I think it's disgraceful.
Chair recognizes Mr. Cloud.
Thank you, Mr. Chairman. One thing was noted in the Clintons' letters is they said the subpoenas were illegal. I'd be curious to know if the ranking member thinks that they're illegal. And with that, I'd yield the rest of my time to you.
Thank you, Mr. Cloud. I want to make sure everyone is aware. On February 11th, Attorney General Bondi will be appearing as the sole witness in front of the Judiciary Committee. Ms. Crockett is a member of the Judiciary Committee. I would assume, I don't want to speak for Ms. Crockett, but I would assume you'll ask her questions about the Epstein investigation and her progress towards releasing the documents. Mr. Massey is a member of the Judiciary Committee. He's already stated publicly he's going to spend his 5 minutes asking the Attorney General about the Epstein documents. So the Attorney General is slated to be in front of Congress, and I'm pretty confident that just about everybody on that committee is going to ask the Attorney General where we are with the document production. So I think that's important to note. February 11th, she's slated to be in front of the Judiciary Committee. And with the discharge petition, when the House voted for that, we issued the subpoenas for the Epstein documents. Then we all voted for the discharge petition. The discharge petition has jurisdiction in the Judiciary Committee. So she's going to be in front of the Judiciary Committee. The next week we're in session. So I think that's important to note. Do any other members seek? Okay, Mr. Lynch, then, yeah, go ahead.
Thank you, Mr. Chairman. I would remind the gentleman, and I'm sure he knows this, that the Oversight Committee is the principal investigatory committee in the House. And we have a responsibility. It may be a shared responsibility with Judiciary, but we nevertheless have a responsibility. And we are the ones who issued that subpoena. This committee did. We are the ones who sat with the victims, right? We looked them in the eye. including the Speaker of the House, we looked them in the eye, these women who have been struggling to get justice for many, many years, and we promised them, every member of this committee, we promised them that we would do everything under our power to make sure they finally receive justice. And here we are today. Now, with millions and millions of documents requested back in August, we've still received, what, 1% of the documents? This is evidence of wrongdoing in many cases, and yet we're allowing Attorney General Bondi to obstruct justice, basically. Even the little bit of evidence that she has provided, she also included a statement that basically said, don't believe this evidence, there's a lot of falsity in these. I mean, I have never seen an Attorney General in this country provide evidence and then give an opinion on that evidence to the legislature, to the Congress. That is unheard of. But it shows her willingness to do whatever she can to obstruct justice from being delivered. The second thing I want to say is, if we are truly interested in getting information relative to this investigation, there should be some underlying basis for that. And I have reviewed all of the evidence that's been made available so far. I find nothing that points to Secretary Clinton in this at all. Yes, she was Secretary of State at one point, but the information that we're trying to get with respect to Secretary of State is available from any Secretary of State that served in that office with respect to trafficking. So there is no direct reason, no direct evidence to point to Secretary Clinton in any of this, and yet while those millions of documents are being denied us, we're pulling someone forward, I think, for the point of embarrassment, public embarrassment, and because of ill will on the part of the president, to bring her forward for embarrassment, but not for the purpose of gaining helpful information for this investigation. Mr. Chairman, I'll yield the balance of my time to the ranking member, Mr. Garcia.
Thank you, Congressman Lynch. Mr. Comer, I just want to be pretty clear about two things, and one particularly something that you said. Let me just start by saying that you noted in your comments that your concern and your biggest concern was the issue of the transcript. And I want to just go back really quick, because you and I share respect for subpoenas. Mm-hmm. You and I share that we want the former president to answer questions. Is that correct?
Correct.
Great. And so does every other member of this committee. We want the former president to answer questions of this committee, and we want not just the former president, but everyone to follow subpoenas of this committee. So let's agree on that. But to be clear, President Clinton, the former president, has submitted a signed declaration. He's offered to sit with you and me and answer questions. He's offered to have staff in the room to transcribe and be there while those questions are being answered. And his request was to do it in a dignified way. Your concern, as you brought up in your last comments, was that he was unwilling to do a recorded transcript. That's actually also not true. And to be clear, there's been public reporting, including in articles that came out over the weekend, that they have not ruled out a recorded transcript. I want to ask the president questions. Chairman Comer, I want to ask President Clinton questions. Don't you?
That's why we're here.
I want to ask President Clinton questions and a recorded transcript, and with our members of our staff. Would you like to do that also?
May I make a comment on the transcript? They have not agreed to a transcript. Staff notes are not equivalent to a transcript.
They've actually made public reporting.
So they're wanting me to make note. They said, okay, Comer can take notes, but they've called us all liars, and you know how the Clintons have gone on offense, and look, they don't get to make the rules. We make the rules.
Can I have the rest of my time back?
Yeah, go
Okay,
ahead.
thank you. I want to be clear, because this is an email actually that from the Clinton lawyers. You have this actually. To be clear, at no point were we opposed to the creation of a record of the interview, which is why we offered to allow the note takers previously. They go on. You have this email, sir. So I guess my question to you is, do you want to sit down and ask President Clinton questions? Actually, can I have my time back?
Will the ranking member yield to
We'll
a
recognize
question?
Garcia, then Mr. Donalds will be next. So.
Thank you. So my question to you, Mr. Comer, again, is if we want to actually ask questions of President Clinton, of which those of us in the minority want to do, then let's get him in. Let's negotiate a recorded transcription of that interview to further our investigation. I thank you for the yield, Mr. Lynch.
Time's expired. Chair recognizes Mr. Donalds.
Yeah, Chairman, point of clarification. Both President Clinton and Secretary Clinton were subpoenaed by this committee to come in for a transcribed interview. Is that correct?
For a deposition.
Excuse me, for a deposition. Chairman, I've been in these closed depositions a number of times in my time being on the Oversight Committee. I fail to see what President Clinton's talking about with respect to a dignified manner. Every time I've been involved in any of these conversations, even when it was former President Biden's son came in for one of those, and I'm not trying to bring up all the Hunter stuff. It's just a point I'm making. I think everybody just take the temperature down, relax. Even those the closed-door depositions have always been held in a dignified manner. Members have had questions outside of questions from committee staff, but members on both sides of the aisle had an ability to answer those questions. Those interviews are recorded. The transcripts of those interviews are provided to the public. I fail to see what special accommodations President Clinton and Secretary Clinton were looking for. Chairman, can you help me understand this? Or even a ranking member. I'm really trying to understand. I'm not trying to make a point. We do too much of that here. I'm trying to understand, because if we're holding a new meeting to replace what the committee already requested, my question is why?
I'm happy to answer.
Mr. Garcia is willing to answer the question.
Yeah. Thank you, Mr. Donalds. I appreciate the question. Look, I think the committee first, I'm not here to defend the Clintons, to be clear. That's their job is to negotiate with the committee, and in this case, you have the majority. Their job is to negotiate with the majority on coming in for a binding subpoena, to be clear. But I'll also note that this committee has historically made accommodations for a variety of folks. In fact, I think it is a bit hypocritical that when this very subpoena for the Clintons were actually made, I believe there were an additional 5 to 6 other subpoenas that were issued to numerous other members of former administrations, attorney generals, and so forth. Every one of those other subpoenas, I think maybe with the exception of one, were given special accommodations. In fact, they were actually allowed to just send their responses in writing. Is that correct, Mr. Comer?
That is. May I respond to that?
Yes, in just one second. And so accommodations are made. And so while every other folks in that group were given special accommodations, that's been typically the case. And I'll finally say just this. Like you, I want to have President Clinton answer questions. I think they are trying to negotiate that with the majority, and they have been clear that it being transcribed is not an issue. They have not ruled that out. And so let's negotiate with the Clintons, and let's get them to answer our questions.
I mean, Chairman, since I guess we're on my time, and by the way, ranking member, thank you for that. I appreciate that. Chairman, you were mentioning you were going to inject your commentary with respect to special accommodations that have been made for previous witnesses. I don't know if you want to expound on what the ranking member said or not.
I would love to. So, first of all, you talk about ongoing negotiations. We have been negotiating for 5 months. This is clearly a stall tactic, hoping that the time clock runs out and the House flips and that you all let them off the hook. But secondly, you mentioned, and I mentioned this in my open statement, there were names on that initial list with the Summerlee motion and the Scott Perry amendment, Attorney General Holder, Lynch, Sessions, and Garland, as well as Comey. They all complied and had written statements under the penalty of perjury that they had no knowledge of anything with Epstein, that they weren't directly involved in the investigation and, basically had no personal relationship. I think we would all agree the Clintons had a personal relationship with both with both Epstein and Maxwell. You know, it's from the evidence that we've received thus far from the estate and all the other documents that we have thus far, it appears that Jeffrey Epstein visited the Clinton White House 17 times while he was president, and then post-presidency, it appears that Bill Clinton flew on Epstein's plane at least 27 times. So there's a huge difference between the knowledge and relationship with the Clintons and Epstein and Maxwell versus the former attorneys general. And another note, I don't know if it was Mr. Bell or whoever said that we only are interested in Democrats. We grilled Bill Barr and Alex Acosta, and they are very Republicans. In fact, they were members of the Trump cabinet. Now, I've been on the Oversight Committee 9 years. We've had 4 other committee chairs. We've had Jason, since I've been here, we've had Jason Chaffetz, Trey Gowdy, Elijah Cummings, and Carolyn Maloney. I don't ever remember a time, and I could be wrong. If I am, I'm sure you all will correct me, but I don't remember a time when Carolyn Maloney or Elijah Cummings subpoenaed a high-ranking Democrat to come in for a grilling. So to imply that this is partisan, that is just simply not true. We've already had 2 very high, the former Attorney General of the United States under Trump and the former Labor Secretary and U.S. Attorney. So we've done that. And then one other thing with the Clintons, and I'll yield back. One of the arguments the Clintons made, Mr. Garcia, was that our subpoenas were unlawful. Do you agree that the subpoenas we issued the Clintons are unlawful?
I believe that all of our subpoenas that we have issued have been lawful, sir.
Okay. Just any other members seek recognition?
Ms. Brown, sir.
Ms. Brown.
It's clear to me that the purpose of this meeting today is just to continue this committee's agenda of political theater, plain and simple. Democrats have been very clear, abundantly, repeatedly, and without room for ambiguity. We want to hear from anyone who has information about the Epstein crimes. And yet, when former Clinton, President Clinton and former Secretary Clinton offered to cooperate with this committee to submit sworn statements, to provide what they know, to engage in good faith, the majority said no. And that's what brings us to why we are really here today. The majority is rushing to hold in contempt 2 private citizens who have demonstrated their desire to cooperate with this committee and who have called for the release of every file on Jeffrey Epstein, all while the Department of Justice and Attorney General Pam Bondi are breaking the law in plain sight. Here are the facts. The DOJ was required by statute to release the Epstein files by December 19th, 2025. The deadline has passed by more than a month. And what have we received? 1%. 1% is not compliance. 1% is not transparency. 1% is a cover-up. What about the 1% they actually release? We've seen redactions that are extensive, unusual, and very likely illegal. And what's more, the Epstein Files Release Act, passed by supermajorities in this Congress and signed into law by this president, required the DOJ to send a report to Congress by January 3rd, 2026. More than 2 weeks later, what have we received from the DOJ? Nothing. So if my colleagues on the other side of the aisle were really serious about uncovering the truth and government and accountability, we would be demanding answers from the administration. We would be demanding answers from Attorney General Bondi. We would be demanding the release of the 99% of the Epstein files still sitting at the DOJ. So I have some very simple questions. Where is the subpoena for Attorney General Bondi? Where is the hearing on DOJ's failure to comply with the Epstein Files Transparency Act? Where is the accountability for the redactions page after page after page? This vote feels less like oversight and more like a distraction. A distraction from the DOJ's lawlessness, a distraction from a broken promise of transparency, a distraction from the embarrassment of a co-equal branch of government choosing complicity over accountability, and a distraction from survivors who deserve this truth. If this committee is serious, then we must hold the Department of Justice accountable. Release the files, all of them, and stop playing politics with justice. Survivors deserve better. And with that, I yield the balance of my time to the ranking member.
Thank you, Representative Brown. I just want to Chairman, I want to just respond to something that you said. I think it's important. First, I just want to read the folks of who the subpoenas you have chosen not to enforce. Alberto Gonzalez, who we subpoenaed on that same day, I believe, you did not enforce. Eric Holder, of course, former AG, did not enforce. Loretta Lynch, you chose not to enforce. Jeff Sessions, you chose not to enforce. Merrick Garland, who I think it'd be important to have answer questions, you chose not to enforce. Robert James Comey, you chose not to enforce. In fact, I have Attorney General Gonzalez's letter. It says, Dear Chairman Comer, this letter is to confirm that consistent with my conversations with the committee general counsel, I have no present memory or decisions or conversations related to the investigation and prosecution of Epstein matter during my tenure as U.S. Attorney General. He, of course, was the Attorney General when the whole Alex Acosta U.S. Attorney matter was in front of a critical time in this investigation. Now, you chose not to enforce that because you mentioned that this letter is under penalty of perjury. The declaration that Clinton's also made and sent to you to answer some of those questions were also under penalty of perjury. I just want to clarify that. And then with the remainder of my time, Mr. Chairman, I think it's important to note that you've talked a lot about the importance of our subpoenas and that we should all support this committee's subpoenas. And I agree with you, sir, and I want to hear from the Clintons. It's also important to note that we have members of this committee, Congressman Jim Jordan, Congressman Andy Biggs, Congressman Scott Perry, who are obviously very outspoken, which we like to engage with. Now, they're not here, and that's okay. Now, you also know, sir, that all three of them defied legally binding subpoenas issued by the January 6th committee relating to their efforts to overturn the 2020 election. So we should be clear that the majority chooses to be very selective on which subpoenas they want to enforce or talk about. We have members of the majority that themselves have defied subpoenas. So once again, I ask you, Mr. Chairman, let's ask President Clinton the questions that we have. Let's have him come in and testify in a way that we can negotiate, and let's get all the release of the files done immediately. Thank you.
Would you yield? Could I respond to that?
Sure, I have no more time, but I'm happy to respond.
So you say we didn't enforce the subpoenas. We did enforce. They complied and testified under the penalty of perjury that they had no knowledge. Now, the Clinton declarations were short bullet points, almost like talking points. And the evidence is clear that the Clintons did have relationship with them. Now, again, I've said publicly millions of times, there's no one's accusing the Clintons of wrongdoing, but the fact that they were that close, and the fact that I've never seen a sit-down interview with Bill Clinton where he's answered questions about his relationship with Epstein and Maxwell like the current president has. So we have complied and enforced all of our subpoenas, 100% of our subpoenas. So I just want to make that very clear.
Can I respond to you, sir? Sure. Just to be clear, you're talking about two declarations. The declaration that you chose to use as something that you moved on to not bring him in was 1/6 the size of the Clinton declaration. I'm looking at the Alberto Gonzalez response to you, sir, that you chose to dismiss, and it is one sentence long. You just pointed out the Clinton declaration, which is 6 times as long. And so I just think you are using interesting points to make comparisons. Let's just be clear and get back to the facts. Let's bring President Clinton in to have a conversation with this committee. You are instead choosing to try to prosecute President Clinton and send him to jail, which is part of criminal prosecution, before having him answer questions to this committee. Him and his team have been trying to negotiate. We want to hear from President Clinton. I'm not sure that you do, sir.
You don't think I want to hear from President
Chairman
Clinton?
Comer, can I Chairman?
So